Hello, my name is Mike Luksic. I'm a professional geologist with the Department of Conservation, Office of Mine Reclamation. Thank you for the permission to address the Commission regarding the Surface Mining and Reclamation Act of 1975, SMARA, and implications of the county's decision on vested rights for the Blue Lead Nevada County mine. I'm adding Nevada County to the name Blue Lead Mine because there is already a mine named Blue Lead in Butte County and a state mine ID number. The Blue Lead Nevada County mine has never been in compliance with SMARA and cannot be assigned a specific state ID number until it is. The department notes that under SMARA, the legislature provided owners of pre-1976 mines with a choice. They are either 1, surface mining operations subject to all the requirements of SMARA, responsible for submitting an adequate reclamation plan and financial assurances, among other things, or 2, they are no longer mining operations, not subject to any requirements, and not entitled to the privileges of vesting. The Blue Lead Mine, Nevada County, appears to want to be a mine for the purposes of vesting, avoiding permits, and avoiding CEQA, but not to be considered a mine for the purposes of complying with the Surface Mining and Reclamation Act. Unfortunately, a mining operation cannot have it both ways. The Department of Conservation has reviewed the items submitted in support of a vested rights determination for the Blue Lead Mine, and Nevada County's materials prepared for the Planning Commission hearing on vested rights. Under SMARA, it is the responsibility of the lead agency, in this case Nevada County, to determine if mining was occurring in 1976 and has occurred without break since, thus ensuring a vested right. As this is a local decision, the department will not comment on the determination. However, based upon Blue Lead's assertion that they have made a mining operation since at least 1983, the department provides the following to Nevada County to use in their proceedings as appropriate. Since 1991, every mine in the state, whether active or idle, has been required to send an annual mine report to the department and to the county, documenting their status and mineral production. Blue Lead Mine has never provided this statutorily required annual report, either under the Brady Family Trust ownership or the current ownership. If Blue Lead is indeed a mining operation, they have been in violation of this statute for 19 years and cannot provide the production and intent to mine that those reports were designed to provide. Since 1976, and affirmed by the legislature in 1988, every mine in the state, vested or not, was required to have a reclamation plan approved by the lead agency, Public Resources Code Section 2776 and Section 2770B. If the Blue Lead Mine is indeed a mining operation, it has continued to violate this statute for 34 years. Any mine violating this provision is prohibited by statute from operating. Since 1991, every mine in the state of California has been required to maintain a financial assurance to guarantee reclamation. If the Blue Lead Mine is indeed a mining operation, it has violated this section of statute for 19 years. Violation of any of the above provisions is subject to a fine of up to $5,000 per day from the first date of violation. If the Blue Lead Mine was indeed a mining operation which violated those statutes, it would be subject to those fines. 19 years times 365 days times 5,000 is equal to $34,675,000. Since 1991, all mining operations were required to pay an annual reporting fee to DOC and submit annual reports, including production to the state and lead agencies. Failure to pay this fee and submit reports is subject to fines, penalties, and interest. If the Blue Lead Mine was indeed a mining operation since 1983, fees, penalties, and interest since 1991 are now due and payable, both from the current operators and the Brady Family Trust. Approximately $250,000 would be owed to the state. As of 1991, any mine in the state which had no production but which had intent to mine in the future was classified as idle and required to obtain an IMP, Interim Management Plan, for approval from the lead agency. The documents submitted by Blue Lead assert that they have been a mining operation since at least 1983 and had intent to mine in the future. Just because a mine existed at some point in somebody's mind does not mean it meets statutory requirements. Failure to obtain an interim management plan within 1 year and 90 days of becoming idle results under statute if the mine in the mine being deemed abandoned and required to reclaim immediately. If the Blue Lead mining operation was indeed a surface mining since 1983 with zero production and an intent to mine, it was classified by statute as idle, and as no IMP was approved, is now deemed by statute as abandoned and required to cease mining and immediately reclaim. If the Blue Lead mine is found by Nevada County to have a vested right and to have a surface mining operation since 1991, the county is responsible for taking measures necessary to enforce all the above SMARA requirements. Failure to enforce measurements would result in OMAR, the Office of Mine Reclamation, performing enforcement duties and referring to the State Mining and Geology Board, Nevada County's SMARA mine regulatory program for all mines in the county. Thus, if the county finds the Blue Lead has indeed been a surface mining operation, it must order the operator to immediately cease mining and reclaim the site, or face loss of its county-wide SMARA authority. Also, the department will take all enforcement and legal actions necessary to collect fees, penalties, and interest owed to the state, and if necessary, to enforce SMARA itself. The right of the county lead agency to issue permits and perform annual inspections and charge fees is the preferred way to fund the local lead agency program. Fees for permit processing, plan review, annual report, inspections, and program enforcement are necessary to support a viable lead agency. Without these sources of funds, Nevada County risks losing their lead agency status. If Nevada County loses its lead agency status to takeover by the State Mining and Geology Board, fees for annual inspections will increase to approximately $5,000 a year for all mine operators in the county. All mine operations should comply with SMARA in order to compete on a level playing field. Illegal clandestine gold mines provide no support for the SMARA program, yet one illegal mine operator can consume the majority of man-hours and lead agency staff have available, necessitating the increase of associated fees paid by legal mine operations. The DOC supports legal mine operations, not illegal clandestine mining.